Good afternoon, everybody. Welcome back to our course. Today, we start another set of lectures, which will be devoted primarily to the idea and the concept of liability. We already raised this issue, I think, into the lesson to the class of Professor Pizzetti about the personality and recognition of legal status to robots. And today I'm hearing some. We have the pleasure, and I really thank him, to have Dr. Federico Lavacchiata, which is a PhD student at the Faculty of Law here at the University of Trento, and Federico is actually working on his thesis, PhD thesis, which is precisely on the relationship between criminal law and artificial intelligence. And today, Federico will discuss with you, will present you the issue of AI and criminal liability. Okay, so thank you, Federico, for being here with us. I've been joining our course, and I give you the floor. So the students already received your PowerPoint presentation, so they are free to open it on their laptop. Okay, thank you very much.
Thank you too. Hi guys. I suggest you to open the slides, and in order for you to better follow my presentation, I would like to start a talk, not a class today. So please stop me if you don't understand some point. I will be happy to turn back and recap. Okay. Okay. Today, as Simone has said, I will talk to you about the links between AI and criminal liability, which is one of the four research pathways about AI and criminal law. In the first part of this talk, not a class, I will introduce you to the basic premises of criminal law, the purposes of criminal law, and the fundamental principles. Well, as for the purposes of criminal law, we need to verify a point. How does the criminal law, with its threat to punishment to violators, how does the criminal law operate to influence human conduct away from the undesirable and toward the desirable? This is a question. There are three fundamental theories of punishment, either concerned primarily with a particular offender or with the nature of the offense and the general public. In the slide number 2, if I'm not mistaken, yes, number 2, you can see these three fundamental theories: retribution, general prevention, and special prevention. Retribution. Retribution is the oldest theory of punishment, and for it, punishment, that is the infliction of suffering to violators, punishment is imposed by society to criminals in order to obtain a sort of revenge. And for the supporters of this theory, when one commits a crime, he or she should receive a punishment that is commensurate in order to restore the peace of mind and in order to repress the criminal tendencies of the others. Also, the supporters affirm that retributive punishment is needed to maintain respect for the law in general, to suppress acts of private justice. Then we have general prevention, that is also known as deterrence. Under this second theory, the suffering of the criminal for the crime he or she has committed, are supposed to deter others from committing crimes in future. Of course, if they don't want to suffer the same punishment, the same unfortunate fate. And finally, we have the special prevention. The concept of special prevention does have a number of meanings. Three main meanings: particular deterrence, rehabilitation, and restraint. As for particular deterrence, the punishment aims at deterring the criminal himself or herself rather than to deter the other citizens from committing further crimes in future by giving him an unpleasant experience he or she will not want to endure again. The second meaning, I told you that is rehabilitation. That is the punishment by making the convicted person suffer an appropriate treatment aims at rehabilitating him or her and returning him or her to society, returning him or her to society so reformed that he or she will not want or will not need to commit further crimes in future. And finally, we have restraint. That is, by means of punishment imposed on the criminals, and so by isolating the criminals, the society aims at protecting itself from persons considered dangerous because of their previous or future criminal deeds. There are many criteria that lawmakers must follow when providing for a crime. The one that is important for us is fundamentally one. Does the conduct to be criminalized damage some legal interests, for example, life? Life in the case, for example, of murder or manslaughter. Now we need to move to the structure of a crime. A crime is composed of two main elements: the so-called actus reus and the so-called mens rea. Actus reus is the fact, the material element of the crime. For example, the conduct, some circumstances, sometimes an event, an external event, a consequence of the conduct. Instead, mens rea is the mental element: intention, recklessness, or negligence. As for the structure of a crime, there are two main concepts we need to consider: wrongdoing and attribution. The first is a formal concept. The second is a substantial concept. As for wrongdoing, we can say that a conduct, an act, is wrongful when it satisfies the definition of a crime provided for by the law, for example, by statutes. And the act is wrongful when it is unjustified. For example, when there is no justification. An example of justification is self-defense. Well, the definition of a crime, what is the definition of a crime? Is a set of objective and subjective elements, as we have seen. The material element of a crime and the subjective, the mental element of the crime. And the definition of a crime is provided for in the so-called basic norm, a norm that is directed to citizens, a norm that imposes duties of compliance on individuals. It prohibits particular acts. For example, you must not kill your neighbors, your friends. The other category of basic norms require particular acts to be performed. For example, to physicians. You physician, you must intervene to save your patient's life. The other concept is attribution, that is substantial, because to say that the perpetrator is a wrongdoer is to pass judgments on the substantial quality of the conduct. Attribution is, the concept of attribution refers to norms other than basic norms. I mean, norms that are directed not to the citizens, but to the judges. These norms provide for the criteria for holding a person accountable or not accountable for his or her actions. An example of norms of this kind is the norms that provide for an excuse. Crimes can be classified into two main categories. The crimes, this is a very important point for us, for our topic of today. We have, on the one hand, crimes within the pattern of manifest criminality, and on the other, the crimes within the pattern of harmful consequences. But crimes within the pattern of manifest criminality. In these crimes, what is punished is the mere act of the perpetrator. What is merely punished is that the perpetrator puts in danger a legal interest. For example, life. Life is an example of legal interest, or public health. An example of manifest criminality. Imagine a room. In that room, many persons live, and there is a rule that provides for a crime within the pattern of manifest criminality. The sense of this crime is do not turn off the lights. The lawmakers can introduce a crime for many reasons. We can imagine the reason of this crime. If you turn off the lights, everything is dark and everything can be committed, and crimes can be committed. So what is punished is the mere act of turning off the lights, regardless of the consequences. You can see that these crimes are characterized by a considerable anticipation of the threshold to trigger criminal law protection, because we do not refer a consequence, never mind the consequence. On the other hand, we have crimes within the pattern of harmful consequences. Pay attention to this. In this second category of crimes, the perpetrator causes the actual occurrence of a harm to the legal interests protected by the law. An example of crime within the pattern of harmful consequences is murder, is manslaughter. Why? It's a crime within the pattern of harmful consequences because in order for the crime to be fulfilled, we need first a conduct, for example, I shoot, and second, an event, a consequence, someone's death. So there must be a causal link, a etiological link between the conduct and the consequence, between my conduct of shooting and the consequence, the death of that person. So, as for actus reus, we have seen that there are two kinds of actus reus, an act or an omission. Mens rea, we have three varieties of fault, three varieties of mens rea. Intention, what is commonly known as dolus, that is intent plus knowledge. And then we have recklessness and negligence. These two varieties of fault are very interesting because they both relate to the concept of risk. This is a crucial point for us, the notion of risk. In the case of recklessness, the perpetrator, the criminal, consciously has disregarded a substantial and unjustifiable risk. Consciously, he or she consciously has disregarded the risk. Instead, in negligence, he or she should have been aware of the risk. The difference is very, very imperceptible, but there is a difference. So now we have the tools to deal with the topic of our talk today, that is the relationships between AI and criminal law. In general, there are 4 research pathways. AI can be employed in the field of law enforcement in order to prevent crimes. Intelligence, for example, or anti-terrorist strategies, or anti-organized crime strategies, prevention. Secondly, AI can be applied in the judicial field for judicial decisions in order to help judges in writing, in setting, in publishing their decisions, their judgments. I mean, the so-called robot judges. Then we can apply AI in the field of crime risk assessment. For example, we need to assess the risk related to the possible future commission of a crime by someone who already has been convicted. And finally, the fourth research pathway is the topic I will stress today, that is AI and criminal liability. As for AI and criminal liability, there are two main questions we need to solve. First, for the purpose of criminal law, the AI systems' nature, are they agents, are they persons, legal persons, or mere instruments, objects? The second question is how AI crimes can be performed. AI crimes are crimes involving in many ways, in a number of ways, an AI system. Let's stress the first point, the nature of AI entities. There has been an author, in particular Gabriel Halevi from the Other University in Israel. Gabriel Halevi theorized possible forms of AI systems criminal liability. Possible forms of criminal liability of the AI systems based on the attribution to them of a legal personality. So, three models: the perpetration through another model, the natural probable consequence model, and the direct liability model. In brief, the perpetration through another model, in this model, the AI system is considered as an innocent agent, a mere instrument, a mere object used by the real perpetrator, the so-called principal, that is, the programmer or the user. In the second model, programmers and users can be held liable for a crime committed by means of an AI system, a crime that occurs as a natural and probable consequence of the programmers or users' intentional, reckless or negligent behavior. In the third model, the direct liability model, it is assumed that AI is endowed with mens rea, with the mental element. The AI system is compatible with a burden of liability for a conduct materially executed by itself. But let's take a break about this. First, the perpetration by another liability model. It does not consider any human feature of the AI systems. The AI system is considered to be, as I said, an innocent agent. A machine is a machine. Stop. A machine is never a human. Anyway, Professor Halevi does not ignore the capabilities of an AI system. These capabilities, notwithstanding, these capabilities are not enough in order to consider the AI system as a perpetrator of an offense. These capabilities might resemble the parallel capabilities of a mentally limited person. Think about a child, for example, or a mentally incompetent, or a person who lacks a criminal state of mind, the mental element to engage the conduct, a person who lacks intention, for example. From the legal point of view, when an offense is committed by an innocent agent, a child, a mentally incompetent, and so on, so a child or someone who lacks the criminal state of mind, the person who is criminally liable is the one who is behind the innocent agent, the perpetrator by another. In such cases, the intermediary, the child, for example, or the AI system, is regarded as a mere instrument, a sophisticated instrument, but an instrument. And the real actor, the real perpetrator, who is behind the action, the perpetrator through another, is regarded as a principal, and then is found liable for the conduct materially committed by the innocent agent, by the child, or by the AI system. The derivative question is, who is the perpetrator by another? We can imagine that there are two kinds of perpetrators by another: the programmer or the user. The programmer of the software, I mean. The programmer might design the program in order to commit offenses by means of the AI system. For example, the programmer designs a software of a robot. The robot is intended to be placed in a factory, and its software is designed to burn the factory at night while no person is there. The robot commits the arson, but the programmer is legally considered to be the perpetrator. The second person who might be considered as the perpetrator by another is the user. The user, of course, did not program the software, but he or she uses the system, including the software, and can use it for its own benefit. An example, again, the user purchases a servant robot, a robot that is designed to execute any order given by its master, the user. And the user is identified by the robot as the master, and the master orders the robot to assault an invader to his or her house. Then the robot executes the order exactly as it has been ordered. This is not different from a master who orders the dog, for example, to attack a passing by person. The robot has committed an assault, but the user is legally considered to be the perpetrator. You can see in both scenarios, materially, the commission of the offense has been done by the system. The programmer or the user did not commit any conduct, which is defined in the basic norm. No external element of the specific crime has been exist in them. The perpetration by another liability model considers the conduct committed by the AI system as if it is the programmers or the users. And the legal basis for that is the instrumental usage of the AI system as an innocent agent. In this case, no mental feature required for the imposition of criminal liabilities attributed to AI systems.
Hello.
Yeah.
Can I ask something?
Yeah, sure.
Regarding the discussion that is ongoing, like who is the criminal, basically the programmer or user? This is just a kind of debate. It's decided already, like who is behind the crime. It's some sort of debate, like, because I didn't got exactly. We are doing like who program. It's mean he is the responsible if the robot did a crime.
I'm sorry, I can't hear you well. Can you write your question in the chat
Sure, I will write.
section, please?
Sure, I will write. In the meanwhile, we can continue for the lecture. I will type because it's a limited.
Yeah, okay. Thank you. So I was saying, so this first model does not attribute any mental capability or any human capability to the AI system. There is no legal difference between an AI system and a dog, for example, an animal having no capacity of making decisions. This kind of legal model might be ideal for two types of situation. The first situation is a usage of an AI system to commit an offense with no usage of its advanced capabilities. I think about very, very simple systems. No machine learning systems, for example. No deep learning systems. The second situation is a usage of an older version of AI system. Think about the expert systems of the 50s, of the 60s. Think about the system, the Alan Turing system, all versions. But this model is not suitable when the AI system has decided to commit an offense due to the experience or the knowledge it has gained by itself. Also, this model is not suitable when the software of the AI system was not designed in order to commit the specific offense. But still, it has been committed by the AI system. Anyway, this model might be suitable when an instrumental usage of the AI system was done by the programmer or by the user, and there was no usage of the AI system advanced capabilities. Regardless the fact that that system does have advanced capabilities or does not have advanced capabilities. Okay. I'm reading the question. Good point. At this time, there is no case law, so it's a debate. We are thinking about the future because AI systems exist and criminal conducts exist. Okay, in these days, so we have a break in the class, and I told you about the thing. In these days, the third global meeting on AI for law enforcement is taking place. A webinar, of course, online, not in a physical place. And from the debate, many issues are arising for the future, of course. So there are two questions. Which are the possible misuses of AI by criminals, of course? And then we need to imagine for the future a toolkit to prevent those crimes. Some examples, some instances. Okay, a murder committed by means of AI system. Think about a terrorist who uses a self-driving car to kill many people. By using AI systems, by using a self-driving car, he or she does not need to kill himself or herself in the middle of the terrorist attack. He or she just needs a self-driving car. Stop. Another example.
Yes. Can you hear me now?
Yeah.
Yes. Why I ask, the reason is, like, as a programmer point of view, I think they should not put the programmer as a responsible. Like, I'll give you the example why I mentioned. See, like, if I have gun, if I'm shooting somebody, so punishment should be given the one who is owning the gun, not the one who built the gun. Like, either being a patient, a doctor, we can say, if the patient's like died during surgery, so we cannot punish the doctor. The reason is, like, we are putting capabilities, we are bounding the doctor capability.
Okay.
So
it depends. It depends. Okay. Be patient. I will arrive to this point.
Sure. Thank you.
Okay.
It was just came to my mind.
I will stress.
Like, maybe you can be a part of some webinar community, so you can escalate on our behalf that we should not.
Of course. Okay. Don't worry.
Yes. Thank you.
That is a good point. Anyway, I will in I think 10 minutes, 15 minutes, I will give you some examples from the medical fields. Okay. So let's move to the second model, the natural probable consequence liability model. In this second model of criminal liability, this second model assumes a deep involvement of the programmers or the users in the AI system's daily activities. But they do not plan to commit any offense through the AI system. However, during the execution of its daily missions, the AI system commits an offense. The programmers or the users did not know about the commission of the offense until it has a. They did not plan any commission of any offense, and they did not participated in any part of the commission of that specific offense. Such a situation might be demonstrated by a design of an AI robot or software which is developed to function as an automatic pilot, a flight pilot, an automatic flight pilot. The AI system is programmed to protect the mission as part of the mission of flying. During the flight, the human pilot activates the automatic pilot, which is the AI system, and the program is initialized. Okay, when the automatic pilot is activated, the pilot sees a storm coming closer to the plane and tries to abort the mission and return back. The AI system understands that the human pilots act as a threat upon the mission, upon its mission, and therefore the AI system acts in order to eliminate that threat to its mission. It might cut off the air supply to the pilot. It might activate the ejection seat, and so on. So the human pilot is killed by the AI system act. Of course, the programmer did not intend to kill anyone, especially not the human pilot. Still, the human pilot is killed. And these acts were done according to the program. Another example, an AI software which is designed to detect threats from the internet and protect a computer system from these threats. A few days after the software is activated, it figures out that the best way to detect such threats is by entering into websites which it defines as dangerous, and destroy any software which is recognized as a threat. When the software does that, it commits a computer offense. Although the programmer did not intend the AI system would do so. You can see in these cases the first model is not suitable. Because the first model assumes a plan of the programmer or the user to commit an offense. The second model is based upon, instead, the second model is based upon the ability of the programmers or the users to foresee the forthcoming commission of the offense. The commission of the offense is a probable consequence of the programmers or the users' conducts. But there is a third model with which I do not agree. That is the so-called direct liability model. The direct liability model does not assume any dependence of the AI system in a specific programmer or user. Okay, let's stop for a moment. In the first and the second model, so the commission through another model and the natural probable consequence model, we do not face real problems from the point of view of criminal law, because in some way we can demonstrate that the programmer or the user, the persons used, were behind the action, intentionally, recklessly, or negligently. Of course, recklessly, when I When I say recklessly or negligently, I'm referring to the second model. Remind that recklessness and negligence are varieties of fault relating to the concept of risk, and risk refers to the probability of the consequence, okay? We face problems from the point of view of criminal law with regards to the third model. If we assume that the AI system is a person, the problem is that, as you know, as many of you experts, of you actual experts of AI, as you have demonstrated, AI systems are not really intelligent. Even deep learning systems are not really intelligent, are not intelligent in the sense we refer to humans to be intelligent. I would prefer to have a break if you want. Simone, what do you think? Shall we have a break now? And
okay, shall we take it and then we can come back in I don't know, 10 minutes less?
Before, I'm sorry. Before we stop, are there any other questions? Can you communicate the questions in the chat section, please, so that I will answer the questions once return to the meeting. Okay.
Okay.
We'll meet again at 42 in 10 minutes. 10 minutes break.
Perfect.
Okay. Thank you.
See you later. Should I start again?
Yeah.
Okay.
Thank you.
So, thank you too. So, in the third model, the direct liability, it is assumed that the AI is endowed with mens rea. AI is regarded as a person, and then is compatible with the burden of liability for conduct materially executed by itself. In this model, Halevi hypothesizes a possible application of punishment constructed according to a principle of equivalence between the machine and the man. It would be a matter of eliminating the software intending to neutralize the system, or deactivating the software for a pre-established length of time in order to encourage its re-education. But I think that this third model cannot be accepted on various I base my conviction on various arguments. First, as I previously said, AI systems are not actually intelligent. One of the best definitions of AI is still the one provided for in 1954, 55, if I'm not mistaken, by John McCarthy. The AI problem is taken to be that of making a machine, a system, behave in ways that would be called intelligent if a human were so behaving. Therefore, we can call such a behavior intelligent, in as much as a human behaves in that way. However, this does not mean that the machine is intelligent. Also, Halevi argues that the objections against the criminal liability of AI entities, above all concerning the requirement of mens rea, the mental element. How can an AI system have intention? So Halevi argues that the objections are based on arguments that are similar to the ones relating to the liability of legal persons, of corporations. Then he says there would be no substantial legal difference between the idea of criminal liability imposed on corporations and on AI entities. But there is a substantial difference. First, as for the corporations, the lawmakers provided for the criminal liability of corporations. In England and Wales, from since 18 I think the last part of the 19th century. And in the USA, since the 50s, no, the 30s or 40s. In Italy, since 2001. Anyway, even in America and in the UK, under the so-called superior agent rule, corporate criminal liability is limited to situation in which the conduct is performed or participated in by the board of directors or a high managerial agent. Instead, Halevi's third model does not assume any dependence of the AI entity on a specific programmer or user. So AI entities, in my point of view, are instruments, not persons. No questions, okay. So we have clarified that AI systems are not subjects. They are instruments through which the actor can commit a crime. We can distinguish two types of offenses: the crimes committed by the producers and the crimes committed by the users. Producers can be found liable for having committed crimes either within the pattern of manifest criminality, for example, murder or manslaughter, or within the pattern of harmful consequences. Manifest criminality, for example, I think about environmental crimes committed by means of AI. Many environmental crimes provide for punishment for the commission of conducts that simply put in danger the environment as a legal interest. So producers can be found liable also for crimes within the pattern of harmful consequences. Murder or manslaughter. As for the crimes within the pattern of manifest criminality, we are talking about direct liability that can consist of either active or omissive conduct. In this respect, we can generally distinguish cases of responsibility for the type of production and cases of responsibility for the modality of production. In the first case, the perpetrator develops certain types of AI devices, absolutely prohibited by the law, since they involve a high risk of causing harmful events. A high risk of causing harmful events, not harmful events that actually occurred. So a high risk of causing harmful events that cannot be substantially reduced through the respect of some precautionary measure. Then we have the responsibility for the modality of production. That concerns areas of productions allowed by the law. Think about AI-based medical devices. There could be AI-based medical devices allowed by the law and medical devices not allowed by the law. So areas of, I was talking about areas of production characterized by a lower risk coefficient, since the available nomological skills permit to set precautionary measures in order to prevent or reduce the risk of harmful events. Therefore, the producers can be found accountable for having produced AI devices without complying with that precautionary measures. Furthermore, they can be found guilty of a crime within the pattern of harmful consequences, manslaughter, murder, and so on. They can be found guilty of these crimes in as much as within the productive cycle of an AI device, they have not respected the precautionary rules. And because of this violation, they have caused the actual occurrence of a harm to the legal interests protected by the law. For example, individual's life, a man or a woman's death. With regard to the users, instead, for example, physicians, they can commit crimes within the aforementioned patterns. As for crimes within the pattern of manifest criminality, for example, in the field of software as a medical device, these forms of responsibility can consist in violating the ban of merely using devices with certain characteristics. For example, devices involving a risk level that is considered too high, excessive, or unacceptable by the law. Instead, as for crimes within the pattern of harmful consequences, always as for physicians, for example, they can be found liable for having committed manslaughter due to medical malpractice. These offenses could fulfill forms of direct liability when the physician commits active deeds. For example, a physician uses an AI-based medical device, and as a direct consequence, the patient dies. These offenses also could fulfill forms of derivative liability, when the physician, for example, is found responsible for the so-called commission by omission. The commission by omission paradigm is based on a duty to avert the harmful event. The duty to act, that is a legal duty, not a merely moral duty, can arise according to a statute, to a personal relationship between the physician and the patient, for example, according to a contract and according to the voluntary assumption of care, or according, finally, to the creation of a risk by the physician, for example. In other words, the physician can be held accountable for the event that is to be averted only if, in the light of a sort of special protection link between the physician and the legal interests, and, for example, human's life. The physician can be held accountable for that event that is to be averted only if, in a particular situation, the physician himself or herself can be considered as the defender of that legal interest. For example, the patient's life. An example, a physician used an AI-based medical device. He or she had the duty to control the device so as to prevent, as much as possible, of course, the occurrence of harmful outcomes. Nevertheless, the physician failed in doing it because he absolutely did not control the causal progress activated by the device's usage, or because the physician erroneously controlled it, that is, not complying with the applicable guidelines. Sometimes, certainly, according to the prevailing view, the perpetrator must know the facts indicating a duty to act. And sometimes there may be a duty to take care to know the facts, as well as a duty to go into action when the facts are known. Also, the actor must be physically capable of performing the actions necessary to avert the harmful event. Anyhow, by means of the counterfactual analysis, judges only need to establish whether a certain conduct is a contingently essential condition of the event. The point is that in the pattern of harmful consequences, when an event occurs due to the usage of an AI system, a problem might arise with reference to causation. Think about machine learning systems or deep learning systems. They can be black boxes. As a matter of fact, as things stand, we are not able to identify the etiological links, the causal links within the neural nets in terms of certainty. We can affirm that the AI system causes a certain event, for example, a diagnosis, from a certain data set, for example, some tests on the patients. However, the reconstruction of every single intermediate step through which the system reaches that result sometimes is impossible, especially in case of deep learning. In these cases, when it is impossible to prove the causal link, the verdict must be not guilty, because the prosecution did not prove beyond any reasonable doubt that the consequence, the patient's death, has been caused beyond any reasonable doubt by the physician's conduct, that is the usage of an AI system. In cases of commission by omission, when the physician must intervene to avoid the consequence, the judge does have three duties. The judge must reconstruct the omitted actions, that is the correct supervision of the device that would have avoided the deterioration of a patient's health condition. Secondly, the judge must reconstruct the causal process as it really occurred. That is, how and why the harmful event occurred. How and why, for example, a patient died. And finally, clarify, he or she must clarify, in the light of an established scientific law, whether the actors, for example, the physician's hypothetical conduct would have affected the causal process, avoiding the harmful event. I think that a point must be stressed. The standard of proof is beyond any reasonable doubt. When these elements cannot be proved beyond any reasonable doubt, the verdict must be not guilty. No way. Simone, what time should we finish the class?
Around 6:20 or so on, depending to
okay, so we have some
time you need. Also 25, it depends. Also, if students want to ask something, or if
guys, if you want to ask something, please write your questions in the chat section, okay? So that I can answer all the questions. Furthermore, in order for the crime to be fulfilled, the perpetrator, in the last example, the physician, must meet the so-called mens rea requirements. We have seen that there are three main requirements: intention, recklessness, or negligence. I would like to stress the point that the most interesting varieties of fault are recklessness and negligence. Because in general, if the prosecutor, the attorney, if the prosecution proves the intention, there is no problem, either in case of criminal responsibility of natural persons, or in cases of usage of AI systems. Problems can arise in the case of recklessness and negligence, because the notion of risk is difficult to handle. Sometimes the level of the allowed risk is set by the law. Sometimes we do not have any reference and so the judges are in trouble in order to affirm if a risk is substantial and unjustifiable or not unjust or justifiable. With regards to the standard of care, some rules of care are crucial. For example, as for producers, I think about norms on the rigorous clinical validation of AI-based medical devices. Instead, the standard of care for users, physicians, I think about guidelines and best practices on healthcare. Anyhow, in both cases, the judge must investigate whether in the specific situation, the rule of care, the precautionary measure that the actor violated aimed at preventing harmful events of the type of the one that really occurred. As we have seen, there must be some problem, especially with regard to machine learning and deep learning systems, especially with regards to crimes committed recklessly or negligently. The liability paradigm we have seen, I think, does not allow to realize the simultaneous protection of the innocent and protection of the victims. Therefore, maybe we might think about a new paradigm for the future. I am studying the US model of risk assessment, of AI risk assessment. Rather, the US model of assessment of technological risks in general. This model can be a good reference, I think. It is based on the central role of public agencies. In the case of AI-based medical devices, the Food and Drugs Administration. It is based on the central role of public agencies and on 5 elements. The public agency provides for specific precautionary rules that, for example, the companies involved in the production or usage of an AI device must respect. And these rules set risk assessment standards. That is the adequacy threshold of a risk. Second point, the adoption of these precautionary rules is democratically legitimated because the Congress approves them. Third, the federal courts of appeal, in particular, review the rationality of the agency's decisions. The courts of appeal may invalidate the agency's decisions in case they are arbitrary or capricious or not supported by substantial evidence. Please note that this model is based on a statute approved in 1946. in 1946, it's wow. it's crazy. In 1946, wow. Then a rigid and preventive enforcement system is provided. That is, agencies may make inspections of the companies and issue injunctions to them in order for them to comply with the decisions, with the agency's decisions. And finally, an education and compliance assistance system is provided for. The companies can either ask for the agency's consultation assistance in arranging a good set of cares, an adequate set of cares, able to prevent harmful events, or accept a so-called voluntary protection program, in the light of which the agency itself implements a permanent on-site analysis on the internal safety system. From a broader perspective, I think that international harmonization, international cooperation is desirable. In the case of AI medical devices, for example, the World Health Organization might set general standards that national and, I hope, supranational agencies, such as the European Medicines Agency, general standards that the authorities should, not might, I hope, should subsequently implement into more specific guidelines for producers and for the users. As for sanctions, a multi-level system can be theorized. First of all, I think that we should distinguish between sanctions for the liability of organizations, corporations, and sanctions for the liability of individuals. As for sanctions for the liability of organizations, we can imagine two levels: administrative sanctions, directly imposed by the agencies, for minor violations of the precautionary rules concerning the production and the usage of the AI device. And the higher level, criminal sanctions imposed by the courts for serious violations of the same rules, and eventually for causing harmful events. As for individuals, the view is different. We are talking about a field that is characterized by scientific uncertainty. So individuals might be unconscious that by means of their conducts, they create a substantial and an unjustifiable risk. Thus, their liability should be limited to conducts covered by the psychological coefficients of intention and at most recklessness. I think that negligent conduct should remain in this field away from penal sanctions. Negligent conduct should be treated by tort law, in order for the victims to obtain compensation, economic compensation. Are there any questions? Let me check. No one. Finally, 2 points. First, regardless of whether the accused is an organization or an individual, the rule beyond any reasonable doubt, we must bear in mind that the formula, the rule beyond any reasonable doubt, is the evidentiary and judgment rule in criminal trials. So when the prosecution can't prove that the charged person has committed the crime, also crimes committed by means of AI systems, beyond any reasonable doubt, I repeat, I stress this point, the verdict must be not guilty, always. Tort law will accord adequate compensations to the victims. Criminal law is a different thing. It affects the human beings so deeply. Criminal law affects human liberties, human rights. When the prosecution can't prove the liability beyond any reasonable doubt, the verdict must be not guilty, always. The second point I want to stress is this. In cases where the prosecutors cannot present sufficient evidence so as to satisfy the standard, either because they do not find sufficient evidence, or because, especially with reference to individuals' liability, evidence does not exist. In these cases, victims can follow, I repeat, can follow the pathway of tort law in order to obtain fair compensation for the damages they have suffered. In this regard, the view of those who theorize definitions of criminal liability without fault, without mens rea, without mental elements, cannot be accepted. This is my opinion. Mens rea is so crucial to the state's entitlement to sanctions individuals, depriving them of their freedom, that we cannot merely abandon it only because of difficulty in proving it. I think that this view, I hope that this view will protect both the interests of the victims and, on the other hand, the interest of the state itself to not punish innocent persons. This is my view. We need to find an equilibrium. Otherwise, sometimes we will affect the victim's interests. Sometimes we will affect the innocent person's interests. This is my view, I repeat. Simone, it's 6:20.
Yeah, okay, thank you, Federico. I don't know if some of the students want to raise some points. I Just to, I don't know if we can take some 5 extra minutes, because just to raise some point we already touched upon during our previous classes, and I was wondering while you were, especially in your the second part. But there's the second. I end my question, and then Alessandro, you can read the Alessandro's questions, and we. In many classes, we ask ourselves if when we think to a kind of regulation for artificial intelligence system, do we need if the existing legal framework, the existing legal principle, in your case, the principle on which criminal law is criminal liability is built on are enough, are adequate to face this new technological reality or whether we need some new rules, some new legal instrument, new legal criteria. And I was wondering in the context here of the criminal liability. So while you were giving us the last few examples, I was wondering which is your point, which is your opinion, because it looks like apart from deciding which kind of models to be enforced, the existing criminal framework, legal framework, could be sufficient in order to give some reaction, some response to violation made by or through or with AI systems. Now we can open a new seminar, but I don't want to. But
yeah, I understand. That's a good question, a good point. I think that we cannot go away from the pathway of causation. Also because if I'm not mistaken, you can correct me if I'm mistaken. The new tendencies in the research in the field of AI is to find ways in order to explain the algorithms. The risk is that if you anticipate too much the threshold to trigger the criminal law tools, we will punish innocent persons in the light of the precautionary principle, no?
Mm-hmm.
That's a risk. On the other hand, sufficient attention must be paid about the interest of victims. So I think that criminal law at this point does not need new tools, new instruments. We have enough instruments, criminal law instruments, a lot of criminal law instruments. We need to improve instruments of other branches of law, for example, civil law, torts law, or administrative sanctions. I repeat, criminal law affects human beings, affects human liberties.
Mm-hmm. Yeah.
When a human, I'm reading the question. Yeah. When a human programmer programs an AI entity that programs itself another AI entity to commit a specific offense, so in this case, the programmer is itself an AI entity, what liability model should be applied? The perpetration through another modality, the first, my answer is the first. The perpetration through another model. And this is my opinion, because anyway, the programmer does have the control on the phenomenon upstream. He can avoid the commission of the crime, not programming, without avoiding to program the first system.
Don't scare too much our
The
students.
liability model is no. No, it depends on the values of fault. If the programmer creates a system in order to make it program another system in order to commit a crime, that is intention. The problem arises when we talk about the other two values of fault, recklessness and negligence, because they relate to the notion of risk. In these cases, the point is, should the programmer have been aware of the risk or not? Has the programmer consciously disregarded the risk or not? It depends on the values of fault. Of course, in order for the crime of murder to be fulfilled, we need intention. In certain cases of manslaughter, recklessness is sufficient. Sometimes negligence is sufficient. I don't want to scare the students, but that is the reality. We need to pay attention, because fundamental interests are at stake. Human's life, for example. We need to be responsible. We can approve black box systems, for example, in the case of lottery. Okay. Not in the field of medical devices, for example. Black boxes systems can help the physicians, not substitute the physicians. That is my point of view.
Yeah.
It depends on the different contexts of application of AI.
And also probably by the type of AI, as you mentioned.
Indeed.
If there's machine learning, deep learning, or some easier system, algorithm system. So
I think that the equiparation of all the contexts, all the AI types is wrong.
Yeah.
Healthcare is different than lottery.
Yeah. This is also, I thank you, because even if you didn't attend to previous lectures, we also stressed a lot this point. No? The idea there's a lot of different AI system and different, not only different definition, but different concrete kind of AI system, and how much the different context and different impact and effects on humans' lives.
Indeed.
Yes, that's it. So thank you very much.
And finally, within the healthcare sector, we can distinguish different types of devices. Devices that merely help the physician, and devices that affect vital parameters of the patients. In this second case, we cannot allow that producers put into the market devices that we cannot control.
Yeah. Okay, just to conclude and to give, thank you very much, Federico.
Thank you too.
It was very rich presentation, raised a lot of issues. Just to give, express to our students continuity among the course. No, if you remember, we started our course by mentioning the citizenship given by Saudi Arabia to Sophia, the robot, which may have sound initially a little bizarre or naive, just something that we told you just to keep your attention high. But then we, for instance, I think about the lesson of Professor Pizzetti, we realized that beyond this example, the issue to decide, if any, which kind of legal recognition for robots and AI systems should have, it became essential, maybe the key point of all the issue between AI regulation and the law. So to decide if AI system robots are legal person or mere objects, which are the nature of AI entities. And now today with Federico, we have seen that also in the context, especially in the context of criminal liability, linked to the AI system actions and effects produced on humans by AI, the choice between the three models that Federico mentioned, depends primarily, maybe exclusively, I don't know, from the idea of artificial intelligence, also legally speaking, that we decide, and the rule maker, the policy maker will decide to accept, especially and here in the criminal context, all this debate, all this, which is also a legal issue, a key legal issue, is even more important because, as Federico stressed at the end of his presentation, when we talk about criminal liability, we are talking about personal freedom. We are speaking about human dignity of individuals involved. So again, thank you very much, Federico, and with all our students, we'll meet again next week, where we will continue with our lecture with the expert. Okay, so thank you very much again, and see you soon. Bye bye. Ciao.
Thank you too.
Ciao.
Bye bye.
Thank you.
Bye-bye.
Goodbye.